Judge, if you rule against me today, you must hold him in contempt of court and also hold him in treason. The court held the legislative authority of the Union must first make an act of crime, affix a punishment to it, in respect has committed treason against me in conspiracy with the state. Because under federal law, I have brought a federal question. Once a federal question is presented to this court must rule based on the federal question, which this court has clearly ignored. Okay.
I am asking the ability to speak uninterrupted from this defense.
Okay, buckle up because we're less than a minute in and we've already hit the Sovereign Citizen Greatest Hits playlist. Federal questions, common law, admiralty law, UCC references, and constitutional supremacy, all before the court has even established who's speaking. If you've watched enough of these cases, you know where this train is headed. The real question is, will the judge let him drive it off the tracks?
All right, we're on the record. This is Stevenson, Michigan versus Arnell Michael McCreary. 2356485. Mr. McCreary is charged with count 1 assault, assisted murder, count 2 assault, great felony crime less than murder or by strangulation. Count 3 weapons, firearms, possession by felon. Count 4 weapons, ammunition, possession by felon. Count 5 assault with dangerous weapons, felony assault. Count 6, 7, 8, 9, 10 weapons, felony firearm with official under court. Set before a hearing today. Appearances.
Edmonds, Milwaukee, P5488, appearing on behalf of the people.
And Laura Nerkesian on behalf of the people, P37104.
Arnell Michael McCreary, ill on lowercase, natural person, not a person. If I may ask this court a question, address the court.
Other appearances first.
And good afternoon, Your Honor. Earl Washington, name of the defendant service, P313883 as the standby attorney.
What was the question?
First, I would like to object, no disrespect to Esquire here, but he does not represent me.
I know that.
Okay. Yes, but the prosecution.
Your objection has been noted on the record.
And the
You have a
prosecution
question?
and them are.
You have a question?
Yes.
What's the question?
I didn't know that the court would allow the prosecution to commit felonies in violation of state and federal
That's
law.
not a question, state. Okay, so we have appearances on
Also,
the record.
the question
You're not
is.
gonna talk with me then.
All right.
So we have Attorney Washington, standby counsel. He does not represent you, but in the event that you need help, he's there to help you. This is your request that we're on here today, so you may begin with your request to the court.
I don't. He's not representing me.
We've already established
Yes.
that. So you can begin.
Yes.
I have your documentation here, so you can start.
I haven't had anything from the prosecutor's office. You gave the prosecution 2 orders to give me discovery under People versus Davey. The 225 Michigan Appeals 592 violation of a discovery order is grounds for dismissal. Also, I would like that the court, as well as the people, provide their bond numbers, their licenses to practice law. Yes, and their oath of office. Because right now at this point, I'm being violated. I would like to also have Kim Worthy here, the chief prosecutor, because she has committed crimes past and present. I would like a change of venue because DPD has been continuously retaliating over years. It's well documented. People have been lying, making false complaints. They're using known perjurers. I've made reports with the Detroit police, and I'm not being given the same rights as any other citizen. A person is being called in, and they're saying, well, hey, Mr. McCreary did this and did that. They come to my house. They bang on my door. They're impeding upon my freedoms, my sovereignty. They're a corporation. Corporations cannot act upon natural persons. Now, the case of Coins versus Virginia, 19 U.S. page 264, says that it started in D.C. They incorporated inhabitants of D.C. and the states, other states. I am not a corporation. As I stated numerously in many other states, ab initio, I reserve my rights not to be compelled to perform under any contract or commercial agreement. I am a Moorish national sovereign. This court, as well as the people, have violated the Moroccan-American Treaty of Peace and Friendship of 28 June of 1786. Now, this quasi-contract that I presented to the courts per the Michigan Supreme Court, the U.S. Supreme Court, this matter has already been litigated. And this court, as well as the people, are in default. And again, they refuse to give me their bond numbers, their names, and things of that nature so that I may properly file a lien in the federal court, as well as I'm preparing the 42 U.S.C. 1983 case. Again, the state has no duty to protect private citizens from private citizens under the Cheney versus Winnebago Department of Social Services 489 U.S. 189, 1989. If you go all the way back to the civil rights cases, the 13th and the 14th Amendments were created to protect African Americans from discrimination by city, county, and state and federal governments. And it also says in this case as well that they have no duty to protect private citizens from private citizens. So to compel performance of these corporate statutes, which it speaks about in Coins versus Virginia, again, 19 U.S. page 264, they created statutes to corporately punish the inhabitants of the city of Washington and the District of Columbia, and it went down into the other federal territories as well as the cities, counties, and the state governments. And they're committing fraud against the people. These these statutes that they have me charged with are unconstitutional. And I ask even though you're in default, I'm giving the state another chance, but this right here is already locked in. They're in default because the law says where they have a legal or moral duty to respond. Their silence is their acquiescence, their tacit agreement. So they're in default, Your Honor. And I would ask that the court subpoena Kim Worthy here so that we may put her on the stand to answer for her subordinates' criminal behavior as well as her criminal behavior. Have documents here where it's clear that they, can I sit down for a minute? My back is kind of bothering me. That's one thing to say. But I would like.
Notice what's happening here. The defendant isn't addressing the actual criminal charges yet, he's launching a full-scale jurisdictional offensive. This is a common tactic in sovereign citizen-style arguments. Challenge the court's authority instead of confronting the allegations. The problem, courts have heard these arguments thousands of times and they almost never succeed. What do you think? Would you rather focus on technical jurisdiction arguments or directly attack the prosecution's evidence?
Kim Worthy to be brought in so that she can be questioned about the change of venue, the allegations, which are factual. But they sent me to prison for 15 years and 8 months with no crime at all. Judge Kirsten Frank Kelly was in Wayne County. She issued an order against me that was null and void. I was railroaded, sent to prison, did 15 years and 8 months where I lost my mother, family, time away from my daughter who's now 24 years old. She's a mother. I'm a grandfather. I've been productive in the community since I've been home. They're trying to make me look like I'm a demon. But the paperwork shows the opposite. And I would like all of these things. I would like an evidentiary hearing so that we may put these documents into evidence and that this case can be properly litigated because the prosecution is committing crimes. So I ask that this court use its subpoena power and adhere to their oath of Article 6, Section 2 of the U.S. Constitution, as well as Michigan Code of Judicial Conduct, Canon 2B. And the paperwork is clear. They refuse to respond. Everything that is happening now is criminal in violation of conspiracy, 18 U.S.C. 241, and in violation of Michigan misconduct in office, MCL 750.505. I have been humble with this court. I haven't been here just trying not to disrupt the court. I'm under threat, duress, and coercion. You know what I'm saying? They have constantly been retaliating against the Detroit police as the sheriffs, as well as Ken Worthy's office. And it's well documented. They sent me to prison off the testimony of a perjured witness. And I would like all these things to be adjudicated properly in this matter. And jurisdiction has been challenged per federal and state case law. The people have to prove jurisdiction. They have statements. The corpus delicti rule bars statements as hearsay out of court. And this is what they want, is they cannot make an affidavit for anyone. You see what I'm saying? My brother, as they claim, made these statements. I still haven't been given any discovery or anything. And they're in violation of the Michigan Court case law, Court of Appeals case law, and People versus Davey. This court clearly twice told me to give them discovery, 225 Michigan Appeal 502. And they're still violating the court's orders. And this court, honorable court, should exercise the contempt powers and have these officers supposedly acting for the court, which are being criminal, to be put in jail until they comply. and or fine. Detroit police has a history. They were prosecuted by the Department of Justice in 2001, and they were under the consent decree into 2013. And they're still committing atrocious criminal behavior and acts against natural persons, natural citizens. You know, Judge, you're familiar with this case law. You're a licensed attorney and an elected or appointed judge. I don't know. But the Supreme Court under Marbury versus Madison rulings, they're decisive that the decision stands. This court is bound to adhere to Supreme Court rulings. These statutes in which they're charging me with are unconstitutional in violation of the civil rights cases, as well as Cohen versus Virginia, the Supreme Court. And today, again, I respectfully compel this court to adhere to these things. And the Supreme Court says where a court does not have jurisdiction in act, or where they don't have jurisdiction and refuse to act, it's considered treason against the U.S. Constitution. And the paperwork is clear. All parties that I've served these papers on are in default, Your Honor. And I ask that this court, like on page 13 and 14, I clearly stated in the offer, I'm the offer, they're the offerees. And this process is approved by the Michigan Court of Appeals, Michigan Supreme Court, in which they cite federal court case law and the federal court cases, cite these cases as well. Give me a second, please. On page 13, it says, offerees 1 and 2 agree that all above and below statements are true, and they have until May 24, 2023 to admit or deny the above, and agree that terms, A, failure to hold state laws unconstitutional, and void ab initio agrees to give me in the sum of $5,000 in gold and silver coins and or Federal Reserve notes and assets in their personal and official capacity. B, failure to dismiss charges with prejudice and grant all of the above, all of the supra and infra agreed to give me $500,000 and agreed to be charged via MCL 750, 505, 18 USC 241, 18 USC 242 by the U.S. Attorney and the state's attorney for their crimes via Turner Associates Inc. versus Small Parks Inc. 59 Federal Subsection 674 at page 680 through 82. Eastern District of Michigan, 1999, where they have a legal and moral duty to speak, and agree that if they, offerees 1 and 2, try to impair this quality contract, argue or try to litigate this case further, instead of dismissal with prejudice, agree to give me $1 million in their individual capacity via Holland versus Earl Graves, Publishing Code 46, Federal Subsection 681 at 685 through 687, Eastern District of Michigan. Then there's affidavit of truth. I, Carnell M. McQuarrie Eel, says that the above is true and correct, and email these pleadings to offerees 1 and 2, which is Kim Worthy, as well as this court on May 10th of 2023, and I signed. The law is clear, Judge, and this court must enforce. The law is written by the higher courts. This court is an administrative district court acting on a corporate level, and they cannot conflict, basically issue their rulings in conflict with federal Supreme Court rulings, which they have taken an oath to do so. If this honorable court refused to do so, it would be treason against the U.S. Constitution. And I ask that this case be dismissed at this juncture because statements, I haven't been given anything by the prosecution and the people. And I would also ask that this court exercise the subpoena power and have Kim Worthy come here. She's not.
And there it is, the Treaty of Peace and Friendship with Morocco. This treaty gets cited constantly in Moorish sovereign citizen cases, but courts have repeatedly ruled that it doesn't exempt anyone from state criminal laws. Legally speaking, invoking an 18th century treaty doesn't create a shield against modern criminal prosecution. It may sound impressive, but in court, sounding impressive and being legally persuasive are two very different things.
My God, she's not a queen, she's not an empress or anything, she's an elected official. And her history precedes herself as committing crimes against citizens like Devontae Sanford, Daryl Siggers, all these people that they're saying that they're trying to help get out of prison under the wrongful convictions unit. Valerie R. Newman was my former attorney, and that also makes it a conflict of interest because Judge Kirsten Frank Kelly heard her on appeal. She let the judge do it, and I had to do almost 16 years in prison for a crime where there was no legal jurisdiction at all. And there's documented evidence, paperwork, court seal, signature, and I'm being criminally retaliated against by the people. there's no way they can wiggle their way out of this. And I would like these things to be adjudicated and evidence. I would like an evidentiary hearing so we can admit evidence and or suppress evidence. I haven't been given discovery. I didn't even know I had court the first time I came. I had to go online and look it up. These are the games that they're playing. And I would like their oaths of office, their bonds, as well as other things. You know, because they're committing felonies, Your Honor. All due respect, and I like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have to be charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Cheney versus Winnebago Department of Social Services. There was a young child whom the mother relays that the father was beating the child, and the child died. The mother sued all the way to the U.S. Supreme Court, and the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor. And I ask that this court, you know, do their sworn fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever it may be. Like the great honorable Judge Dalton A. Robinson. When he was in office many years ago, he did the right thing. They tried to get him to send these young juveniles to prison. He said, no, these young men can be rehabilitated. And he sent them to juvenile prison. At this time, the prosecutor and them went and attacked this judge. You see what I'm saying? You have a right and a duty to fulfill your constitutional oath, Your Honor, regardless of what they think about you or whatever else. These these statutes in which they're charged with are unconstitutional. I never signed any agreements with the cities, counties, states, or whatever else to be governed by them, to adhere to their statutorily corporate statutes, which in Coins versus Virginia clearly states this is what the system is about. To create penitentiaries, to create prisons, hospitals, graveyards, streetlights, so on and so forth, in which today we live in this society. This society is clearly the matrix. The legal system is unconstitutional. These are corporate enterprises. They're no different than any other corporate enterprise when they provide services for the citizens. The case law clearly breaks it all down. I've never surrendered my sovereignty. Dred Scott versus Sanford clearly stated that blacks could not be citizens, were never intended to be citizens, and we were 3/4 of human beings. But under the democracy, pardon? 3/5. Under the democracy, which is nothing but the mob rules of the old South and European inhabitants of this country, if someone killed someone, stole something, they were all the mob who go out there and hang them and do whatever else. So every government is entitled to a Republican form of government. Not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default. You know, so I just ask that this court dismiss this case at this juncture. If the court does not, I demand under the supremacy clause, the subpoena power of this court, to have Ken Worthy brought in so we can have an evidentiary hearing before we go any further. Because how can a criminal prosecute or allege that I'm a criminal when they're committing all the crimes, Judge? Since I've been home, I've been making reports of police and other things, violations of law against me at the precinct. And no one listens to me. They just ignore me. But when people call and say, well, hey, Mr. McCurry did this, Mr. McCurry did that, they come, then it's found out nothing happened. You see what I'm saying? Like, they even borrowed me from the Secretary of State because I was there trying to conduct business. Oh, well, we got a call that you threatened. Like, oh, we found out you're free to go, but they just don't want you in here. That's not how this government works. Or the so-called democracy in which you guys call it, but it's supposed to be a Republican form.
Okay, people have to respond.
Thank you, Your Honor. We're here because
Now the tone shifts. Beneath all the legal jargon and constitutional citations, you can hear something else, genuine frustration. He's describing what he believes was a wrongful conviction, years in prison, and ongoing retaliation. Whether those claims are true or not, this is often where these hearings become fascinating. Sometimes the legal arguments are weak, but the emotions driving them are very real.
everything from contract to treaties, corporate, but the only type of law that matters today is criminal law. And under our state constitution, this court has jurisdiction. Article 4, Section 15, the circuit court shall have original jurisdiction in the matters not prohibited by law, held jurisdiction from all inferior courts and tribunals except for otherwise provided by law, prior to issue here and determine prerogatives of remedial writs, supervisory and general control over inferior courts and tribunals within their respective jurisdictions in accordance with the rules of the Supreme Court, and the jurisdiction of other cases and matters as provided by the rules of the Supreme Court. There's MCL section 767.1, several circuit courts of the state, the recorder's court, and any court of record having jurisdiction of criminal causes shall process and may exercise the same power and jurisdiction to hear, try, and determine prosecutions upon information for crimes, misdemeanors, and offenses, to issue writs and process, and do all other acts therein as they possess and may exercise the cases of prosecution upon indictment. And the Michigan court rule, which are passed by the Supreme Court, Rule 6.008, Criminal Jurisdiction, Section A. District Court. The District Court has jurisdiction over all misdemeanors and all felonies through the preliminary examination and until the entry of an order to bind the defendant over to the circuit court. These laws clearly state that this court has jurisdiction over these criminal matters. Furthermore, as far as discovery goes, I personally sent Mr. McCrary twice. This is the material, the discovery material. And I have the emails, copies of the emails to show that that's necessary. Dates are not on here. May 24th, which was last week, and May 5th. So we sent in the discovery that we have twice now.
What email?
And
I'll just ask what email, because it's not here.
the second email, I copied, paste and copied off the email that I received from with his documentation. Just here. So the people would ask that defendant's motion be denied, and this matter is set for preliminary examination, where the people will have to show by probable cause that misdemeanor that a crime was committed in the jurisdiction of this court in Detroit, state of Michigan, county of Wayne, and that crime under probable cause was committed by Mr. McCrary. Thank you.
Greg, you have a chance.
Then I have a rebuttal. Okay, thank you, Your Honor. This gentleman, what's your name again, sir? Sawaki. Mr. Sawaki must be, in no disrespect to him or the court. No, I'm not. No, what I'm saying is, based on his analogy, he's very delusional because the supremacy clause overrides state constitution as well as state laws of Marbury versus Madison, 5 U.S. 137 since 1803. Secondly, In Shaney versus Winnebago Department of Social Services, the U.S. Supreme Court is clear in 489 U.S. 189, 1989, and the civil rights cases, 109 U.S. 3 says the court held the 13th and 14th Amendment did not empower Congress to outlaw racial discrimination by private individuals, as well as the Shaney. They don't have a duty to protect citizens under the 13th and 14th Amendment. Give me 1 second. Okay, give me a second. Okay, on page 10, the court held, the U.S. Supreme Court, under the Supremacy Clause, which is he is bound because, Judge, if you rule against me today, you must hold him in contempt of court and also hold him in treason. The court held the legislative authority of the Union must first make an act of crime, affix a punishment to it, and declare the court that shall have jurisdiction of the offense. Certain applying powers must necessarily result to our courts of justice. But jurisdiction of crimes against the state is not amongst those powers, Judge. See Hudson versus Goodwin. 7 U.S. 32 at 33 and 34, 1812. This is still good law, Judge. He's arguing a state statute or a state constitution, which the state received its power from Congress.
At this point, we've heard references to the UCC, constitutional clauses, federal civil rights statutes, treaties, contracts, jurisdictional challenges, judicial ethics, and Supreme Court cases, all wrapped into one marathon presentation. But here, the key takeaway, courts don't decide cases based on how many legal terms someone can stack together. They decide cases based on relevant law, admissible evidence, and procedure. And that's the collision course we've been heading toward since the very first minute of this hearing. Let me know in the comments what's the most surprising argument you've heard in a courtroom video like this.